Presentation of Dialogue on Idaho Public Television is made possible through the generous support of the Laura Moore Cunningham Foundation, committed to fulfilling the Moore family's legacy of building the great state of Idaho.
Coming up, a United States Supreme Court justice talks about the values that guide him as he makes decisions for the highest court in the land. A conversation with Justice Stephen Breyer next on Dialogue. Hello and welcome to Dialogue. I'm Marcia Franklin. A welcome as well to our public radio listeners. We usually see the 9 justices of the United States Supreme Court in solemn pictures, standing stiffly in their black robes. Their hearings aren't televised and they're constrained in what they can say in public. So in some sense, they can seem remote. But of course, they're human, and several of the justices do travel the country and even internationally, promoting the rule of law and democracy. One such justice is Stephen Breyer. Appointed to the court by President Bill Clinton in 1994, his judicial philosophy, which allows for flexibility in interpreting the Constitution, is considered to be a counterpoint to Justice Antonin Scalia's more literal approach. Now, Breyer has published a book outlining his philosophy called Active Liberty. I had the opportunity to speak with him about it at the Sun Valley Writers Conference in August of 2006. We first talked about the importance of writing for judges. In point of fact, all judges really need to concentrate on writing because your words have to be understood by so many people. They have such a great effect and they live on well past the time that you're here. So writing is really something that is important to all judges, isn't it?
Yes, I think being clear, trying to be clear. When I was first appointed to the court, I said, well, I'd like to write my opinion so a high school student, a senior anyway, can understand them if they make the effort. And I do try to write so that people can understand it. But I have to admit, a few friends of mine pick up some opinion I wrote about some section of the tax code, and they remind me of what I said, and they say, ha, ha, ha. But I think that is an objective for judges. I think you should try to write so that someone who's not a lawyer, but is willing to put in a little time and effort, can understand what your point is. Going
to why you wrote the book, some of the impetus for it actually came out of a meeting that you and Justice O'Connor and Justice Kennedy had with a philanthropist in the United States about how to work on teaching these issues. Is that right?
Yes. Well, Mrs. Annenberg and Bartan Gregorian, who runs the Carnegie Foundation, were having a meeting, and they wanted us to be there. They thought it's very important to teach more about government to high school students. And they had a list of parts of the Constitution that lawyers and others thought were the most important. And some said the First Amendment, free expression, free religion, equality. But way down on the list was the word that the three of us said, well, that's what the Constitution is basically about. That's the most important. And that word was democracy. The whole object of the system, the whole object is to say government, judges, the Constitution, that isn't what tells people what to do. It gives people the right to decide for themselves what to do. Now that is at the heart of the document. And it's not the whole thing. There are other parts very important. It's a certain kind of a democracy. It protects basic human rights. It assures a certain level of equality. It makes certain that power is divided between states and federal government and among different branches so nobody gets too powerful. And it insists upon a rule of law. But those words qualify. The heart is democracy.
And did you feel that people didn't understand that well enough, and that's why you wanted to write the book?
I think they take it for granted. I think they know it so well, it's like breathing, you don't see the air. I think they know that that's the kind of government they're supposed to have. But I think sometimes they forget about it.
One of the other reasons that you've said that you wanted to write the book is to demystify the court a little bit. Again, explaining to people that you're not telling people what to do. You've likened yourself to the Border Patrol, and the meaning that you work along the borders of the Constitution.
Yes. Yes, I think that it is important that people see that, because there's a tremendous temptation to think that what the judges do is tell people what to do. Well, that's not what judges are supposed to do. Now, the document, the Constitution, as I say, sets up a certain kind of democracy, protecting human liberties and so forth. Now, it has words there, and those words create the system. And the job of the judges is to see that the decisions that the process makes, that they fall within the boundary, that they're within the rails, that the Constitution provides. That's our job. Is this inside or outside what the Constitution permits? Now, life at the boundary there, which I think we are patrolling, is not easy, because there are a lot of very difficult questions that come up. Very difficult. And our court, which, by the way, is unanimous almost half the time. I mean, you just read about, because you're part of the press, and you want to write about the most controversial things. Well, those 5-4 cases, 5-4, 4-5, and they're about 20 or 25%. And it's not always the same 5 people and the same 4. But when you do get to those cases, a lot of them are very difficult, and there's a lot to be said on both sides. And they can be tremendously controversial. Abortion, prayer in schools. Do those fall inside or outside? And believe me, there are at least 2 good positions and maybe 50 good positions on those things. Well, when we decide cases like that, they do become controversial. And people do disagree no matter how we go. But it's important to remember that those are the exceptions. It's important to remember that we are talking about the boundary. And no matter how we decide, there's vast area within those constitutional boundaries where people will decide and must decide for themselves how their communities will be governed, what laws they'll have, what rules they want to live by.
So that would be your response to people who talk about activist judges.
Activist is an insult. No judge should be an activist. No one thinks of himself as an activist. No judge does. They do think of themselves as interpreting those words of the Constitution that way or the other way. But as a reviewer wrote when they talked about the book, and I think that is a good theme, it's such a good line, I wish I'd said it. But they said what this says, and what I do believe, is you don't need activist judges. What you do need are activist citizens.
Well, let's talk about that. The book is called Active Liberty, which you also call the liberty of the ancients. And it means the freedom for people to participate in government itself, which, as you say, some people now often take for granted.
Yes. So much that they don't do it, which is a pity, because then they'll get results they don't like.
You have said that judges, when deciding tough cases, should look at this concept of active liberty very highly, if not the highest element that they use to figure out how to decide cases.
Some cases that at first glance you would think really are not directly about democracy. Interpreting the First Amendment, for example. Interpreting the words freedom of speech. How do those words apply to rules that regulate the amount of money you can give to campaigns? Is that constitutional or isn't it? The words that govern it are the freedom of speech. Congress shall make no law abridging the freedom of speech. Well, that doesn't define itself. And if you think of the freedom of speech being part of a constitution, the basic aim of which is to have elections where all citizens can participate, if you think of it that way, it helps you understand how those words, the freedom of speech, might apply to a law that governs campaign contributions.
In other words, if somebody wants to give $10 million to somebody, now we have laws that say, well, we're going to put a cap on that.
Yes.
And the rich person says, well, wait a minute, that's abridging my freedom of speech.
Absolutely.
And you
I say, yes, you're right about that. It does mean that you can't sponsor as much speech as you'd like to sponsor, and that's a problem. But on the other hand, if we let you give 10 million, 20 million, 30 million to a candidate, it's going to be pretty hard for others to get into the act. It's going to be hard to have a $5 contribution make a difference. And that's a problem too, So it makes you see that there are freedom of speech issues on both sides of this question.
How do you define active liberty so that people understand it?
You did a good job. I thought that that was a good way of saying it. Active liberty is meant to refer to the idea of people sharing. That's the old Greek idea. The idea of people themselves, each individual sharing in the acts of government.
Another example in here that folks, particularly in Boise, will be familiar with has to do with the Ten Commandments Monument, because we're dealing with a similar issue. You were the only justice in the majority on both the cases having to do with this issue. In one instance, the court held that the monument could stand, in another, that it needed to go. How do those cases help promote active liberty?
I have to back up a step. I have to answer that question in 2 steps. A little long. But the step 1 is I'm really dealing with an objection to active liberty. So somebody might come along, not saying you, but there are people who say, well, so you're completely off base, Breyer. You are really off base.
George Will.
Well, I'm not naming any names. You say, I've never seen anything so wrong. What you should be doing as a judge is you should be going back and you should look at what James Madison and the others wanted and stick to what they wanted and stick to the words and stop right there. So you're off base in even writing this book at all. That's all you should do. So I want to say, what's that argument about? Because I've got to show that the argument is at least questionable, or I can't even write the book.
What we call the literalist or textualist argument.
Correct.
Which Justice Scalia is a proponent of.
I think he is, yeah. And so I say, well, what's this argument really about? Now, in trying to answer that question, I say most judges, probably all, when they come to a text, a word that's pretty hard to interpret, and indeed, if it wasn't hard to interpret in the case, what's the case doing in the Supreme Court of the United States? I mean, we only get cases that are hard. All right, so most judges, when they have a hard problem, they have 6 tools. You look first to the text. What's the word? What does it say? What's the meaning of that word? Second, the history. What's the history? How did it get there in that text? The tradition. What do those words mean in our tradition? Freedom of speech, for example. The precedent. What did earlier cases say? That's 4. 5, the purpose, the basic value. What's this about? What's the value? The value of the free speech part is speech. The value of the Fourth Amendment is privacy. It's freedom from unreasonable searches and seizures. There's a value that underlies that, or a purpose. And then 6, what are the consequences? I mean, if I decide this way, what are the consequences? If I decide that way, what are the consequences? Consequences that are related to the value. Now, all 6 are there. Now, some people who are more literalists say, do the first 4. Text, history, tradition, precedent. Forget the last 2 most of the time. I say, and the others, I think more, and I'm one of them, would say, pay a lot of attention to purpose, pay a lot of attention to value, pay a lot of attention to consequence. And that is how we make the Constitution, which incorporates values that don't change. The values are the same, but circumstances change. And today's circumstances are different from 1789. So that's what I'm writing about there. And the example you brought up is an example that has to do with that.
The Ten Commandments
That's
monuments.
Right.
And so you found that one monument that had been there for a long time and really there was no controversy over, and there were other monuments around it. It was okay to stay. But another
couldn't, because there I'm trying to illustrate how what I mean by this approach, and I say the first part of the First Amendment says Congress shall make no law respecting an establishment of religion. Well, that's a tough one. What does that word establishment mean? And over time, it's come to mean governments stay out of religion. Not completely. Now, that's where that's difficult, but mostly. And now what does that mostly mean? I say, well, let's go back to the purpose. Why did they put that in the Constitution? And I think I think, though everything I say is controversial, but I think it primarily was an agreement by people who lived through the religious wars in England They say, you're Catholic, I'm Protestant. He's Jewish. Well, let's not fight each other and kill each other. We'll make a deal. I practice my religion and teach it to my children. You practice yours. And the government stays out of it. And that brought peace. And that stopped the wars. And that's what is in this Constitution with the word establishment. And that basic value is do not have government action in relation to religion that's likely to produce serious social conflict. Now, with that purpose as my goal, I said in the one case, I think that's just what they're trying to do. They're trying to produce conflict based on religion. That's likely to be the effect. In the other case, that wasn't so. It was put in that state fair, that state capitol ground to advertise a movie, The Ten Commandments. There's a long history there. I'm oversimplifying, but you'd have to read the detailed facts to see why I came to that conclusion.
But one monument you felt was really could provoke strife between people.
Yes, strife, that's it.
Now, I was always taught growing up that judges decide cases on their face, on the merits, on the face. This idea of trying to predict consequences out into the future, you don't have a crystal ball, obviously.
Of course I don't. Of course I don't. And of course you can be wrong, and of course you can't do it too well. But sometimes you have to. Sometimes you have to, there are a lot of instances where the first thing a judge wants to know, I mean, two landowners, one is suing the other, and the other says, my goodness, he says, if he puts that dam up on his property, before you know it, I'll have a flood in my house. Well, there's no way the judge can decide that case without knowing, is that going to be true or isn't it going to be true? Will there be a flood or not? And that's why we have trials, and that's why they introduce facts. And so consequences, you can guess wrong sometimes, but very often you have to make a stab at it, and you have to do your best.
Are you worried that too many judges are just going by the word and divorcing law from life?
Well, when you say, you see, that's a very interesting question. What I try to say here is what the literalists worry about judges who look at these consequences, for example, as I think is necessary, is that the judge will substitute his own subjective point of view for the law. And they're right to worry about that. That is a concern. And I want to say, but judges who are not just looking at the literal text, they're aware of that problem. And if they do it honestly, they won't do it. They won't substitute their own views. They'll do their best not to. And they write down what they think, and others can judge them on that. But what I worry about is just looking to the history is so often the history in a difficult case just doesn't tell us.
Well, and you said if we're supposed to decide all our cases in accordance with some people in the 18th century historically thought, let's hire historians to be judges because I can't do that job.
Well, of course I couldn't. And I mean, my goodness, did people in the 18th century, they wrote word commerce into the Constitution. They didn't know about the internet. They didn't know about automobiles. They didn't know that communication would involve radio and television. Of course you have to take a principle and adjust to it.
Many judges themselves are unelected.
Yes.
So how in a democracy where these values are important to you, can we hold judges, unelected judges, like yourself, accountable, or should we?
Pretty good question. That's what you call the great dilemma of judicial review. And I think the easiest way to think about it is this. Suppose you were, which you personally would not be, but suppose you were the least popular person in the United States. And suppose you were accused of doing something wrong. And suppose you did go into court. Would you want to have your fate decided by a judge who would be held immediately responsible for himself personally if he decided an unpopular thing? Pretty tough. And if you want to have judges who will in fact try to maintain the balance between the president, the Congress, the judiciary, the balance between the federal government and the rights of the states and the rights of the local community, do you want those judges to be subject entirely to the popular will? If they are, you won't protect the minority. You won't protect the state when in fact the federal government is popular. You will not protect You will not protect those who have unpopular opinions. You will not protect those who I said this Constitution wants to protect in respect to their fundamental rights. And that's why the framers of the Constitution said, although this departs from the idea of democracy, we've got to have some people who are judges who will in fact decide when the other branches go too far.
And in fact, the confirmation process is
It's
a bit of a democratic process
correct.
interjecting into. I've heard you speak, and you're very upfront and honest about the fact that of how nervous you were taking on this
It's true.
job.
It's true.
You know,
That's true.
Whether or not you're unelected, it's serious business. And
Yeah,
the first couple years.
Yeah, I was nervous. I mean, that's why you raise an important point, and the people, the judges who are there, the people on the court understand it. They understand that once they're in office, it's very hard to remove them, and as it should be. Now, they're appointed by an elected person. They're confirmed by an elected Senate. When you get there, however, it's hard to remove you, and that's a problem. What controls what we do? Well, with Learned Hand, who was a great judge, he was asked that question. He said, well, what controls you? Why can't you just do whatever you want? And he pointed to the law books in back of him, and he said, those books control me. And what controls us is what you'd call the fact that we only have the power to make decisions in limited areas, and that we're sworn to be faithful to the law. And that means when you tell me, or anyone writes to tell me, we think you've just substituted your own view for the law, that means something to me, and I think it's wrong. And so it's internal, but it's there. It's there in the mind of really any judge. Be careful what you do.
You've said the Constitution can't solve problems. That document trusts people to solve problems themselves. But they aren't participating as much as they used to. And polls even show that when presented with the Bill of Rights, people, not knowing what that is, say, oh, I wouldn't vote for all that stuff in there. What are the consequences of this lack of participation in one's own government?
Bad. I mean, that's why we're at that meeting in Mrs. Annenberg's. I mean, that's why I think it's important, and I think Justice O'Connor does too, and Justice Kennedy and the others from time to time. We try to explain to people what the courts do. We try to explain to people what the Constitution's about as we see it, and the key to this has to be not us and not even the adult audience. I like to think it's the high school student. And above all, I want to say to the high school students, you know, I may be a little dull, but nonetheless, I hope you're going to learn something of how your government works. And that's not just government in Washington. It's government at the state level, it's government at the local level, but you're going to be part of it. Now, you have the right to say, no, I won't be part of it. And I can't make you be part of your own community. But I can tell you this, that if you do not become part of your own community in some way, on a school board or working in a conservation society, or helping fish to preserve the fish, or whatever you like, you know, if you don't participate in the world that you're in outside yourself, I'll tell you, this document, the Constitution that I'm writing about here, this document won't work, because the people who founded this country expected that the average citizen would participate. And so the most important thing I think we can do on the court publicly is to try to get what we see every day out into public view. And what we see is a document that works basically well, a lot better than people think. And help them understand that, teach that in the schools so that the students understand it. I mean, why do I get a little emotional about it? Because every day in my job, I'm sitting in that room. I sit in the room where people decided Brown versus Board of Education. You know, that wasn't me. That made a huge difference to this country, a huge positive difference. I'm sitting in that room. I see people in front of me of every race, every religion, every point of view. And believe me, this is a big country, 300 million people, and my goodness, there are 900 million points of view. And they're all there in our courtroom. And where are they ironing out these differences? They iron out their differences under law. Well, go look at a few other countries. They iron out their differences with guns. And we don't. And that's such a treasure.
You've called it a treasure beyond price.
It is unbelievable. It's taken a civil war. It's taken 80 years of racial segregation. It's taken unbelievable, horrible things. And somehow we've come out of that over 200 years with a country that 300 million people are able to govern themselves without murdering each other with sticks and stones on the street. And they do it under law, and they abide by decisions when they disagree with those decisions. And that is a marvelous treasure.
Because, of course, after Bush v. Gore, people predicted, well, maybe protests or whatever, things were quiet.
They didn't. They accepted it, and I was in the minority on that, so I thought the majority was wrong. A lot of people thought the majority was right. A lot thought they were wrong. But the thing that was, and they wrote millions of words about that case, a lot. But my goodness, very few people remarked on what I think was the most remarkable thing. There were no riots. There were no guns in the streets. There were no sticks and stones. People accepted it, even when they disagreed with it. And that is something that judges can't bring about. Lawyers can't bring about. Documents like the Constitution or others can't bring it about. It's all of those things in its history, and it's the ordinary person, the average person who's not a lawyer, understanding the importance of that. People I hear so often, they say, oh my goodness, there's no point, they're never going to agree with me. So I say, hey, I work in a job where people quite often don't agree with me. So what? What I do, if someone doesn't agree with it, I try to convince them. That's what I try to do. And on the court itself, there are disagreements, but I've never heard a voice raised in anger. I have never, in 12 years in that conference room, in the most contentious matters, people are civil. They try to convince each other. I've never heard one member of the court say something insulting about another, not even as a joke. I say, well, you don't have to go. You don't have to be that civil. I mean, I don't mind. You don't. Everybody has to be. I think it works pretty well. But my goodness, what you do have to do when you don't get your way is convince them. Maybe you're right. And listen to what somebody else says. That's called the system of democratic conversation. And that's, I believe, what this document set up.
And how has it been for you to travel around talking about this book? What has it been like?
It's been great for me. It's been
Most
great.
people think of Supreme Court justices in the robes and distant and everything, and you've been right out.
The reason, of course, is Harry Blackmun told me this. He was my predecessor. He said you'll find that people in the country want to know about the court. It isn't the book. The book's, in a sense, an excuse. It is the court. People want to know about the court, and they should know about it. We're not the CIA. Nothing's secret. It shouldn't be secret. It isn't secret. What we do, we explain what we do. And I'm pleased that people want to know about it. And I'm delighted to talk their ear off if they want. That's been a great experience. And the best thing anybody can say to me, which I hear sometimes, and I really like it. It's very positive feedback. If people are listening and they're interested and they ask questions, they say it's sort of reassuring. It's a little reassuring. The government of the United States not so bad as we thought.
Well, thank you for sharing some insights into the court. I really appreciate the time that you've taken, and I hope you enjoy the rest of your stay here in Idaho.
I love it.
Thank you.
Thanks very much.
That's all the time we have. I'd like to thank the organizers of the Sun Valley Writers Conference and Justice Breyer for his time. For more information, check out our website. For Idaho Public Television, I'm Marcia Franklin.